Exactly.
Well, how about, there's a lot of stuff you just said. We talked about how there's different duties of care, about whether a danger is hidden or latent, or if it's obvious or out in the open. So why don't you give everyone a basic example of like a business guest or an invitee case, and then maybe a basic example of a social guest case. What's something that people may have heard of happening where they can understand what we're talking about?
So probably the best example of a social guest, a strong or at least plausible case of liability. Again, it's really difficult, but so you go over to someone's house and you're having a good time, and let's just say in this example, okay, so there are stairs from the first floor to the second floor without a railing. Okay, so that's not latent. You see that immediately, and really they don't even have to point it out to you. But either way, so that can be there. But let's just say in the same situation, there's no railing, but you say, hey, can I go to the bathroom? Yeah, man, it's right there. You walk into the bathroom, and immediately first step, you step in a hole.
Okay.
So that was latent because it wasn't obvious. Whereas if right before you are about to go to the bathroom, you say, oh wait, let me go run upstairs and get something, and you fall off the side of the stairs, it's a trickier case. So that's just that's like that juxtaposition is kind of shows how difficult it is, and it's kind of, I don't know, it's a little bit.
You said something about a hole, and it made me think of the movie when we were kids, Home Alone 2.
Yeah.
He's in that house that's being renovated.
Yeah, those were right.
And there's a gigantic hole in the floor.
Full of
right when they open the door. So like if you invited someone over to your house and you failed to mention the fact that, oh yes, I have no floor when you walk in, that's going to be pretty clear.
Yeah, Home Alone, those were all latent dangers.
Yes, you did not warn someone of those dangers.
Yeah, what was the name of his family?
The McAllisters.
The McAllisters would be in trouble for that.
Certainly. Okay.
Well, but they would also be trespassers, but let's not even
We won't get into trespassers. Trespassers is a whole different, kind of animal. Yeah. And it doesn't happen very often, and there's not a lot of rights that you have as a trespasser, so we won't really touch that.
Right.
So give us kind of that basic example of a business guest or an invitee.
Yeah, so just think going to a store, essentially. Maybe you're going to a museum where a free museum. You're going to an event, a local event held by local government. Maybe, even charity programs. I mean, don't sue charities unless you have to, because it's good what they do. But I'm just giving that as an example. But really think stores. Think shopping malls, stores.
What happens to the person that would cause a case that would be a kind of, a basic example of a case?
Yeah, so especially when it comes to the most common premise liability cases, slip and falls, let's just call them for our purposes, is you go into a store as a customer and you're just doing your thing, you're shopping, like we talked about, there's no legal duty to be paranoid that, something terrible is going to happen. You just are minding your own business, looking to see what you want to buy. And either the two general classifications are foreign substances. A foreign substance causes you to fall. So basically, foreign substance essentially just means something is really on the floor that isn't supposed to be. Let's just say there's produce from, left side of the store that's on the right side of the store, or there's water somewhere, or even like an item that's on the floor. So basically, that's kind of a general category.
So something's on the floor.
Something's on the floor, right?
And I think back to law school and those classic banana peel cases.
Yeah, banana peel.
That kind of, and you think of cartoons and everything of someone slipping on a banana peel, but those actually are some of the things that established some of the things we have now,
right? About
notice and things. And I know we'll get into that.
Yeah.
So just for everyone listening and watching, for business guests, just to recap, you're going into some place that you're benefiting them, like you said, maybe a public place, or it's going to be a business, usually Walmart, grocery store, and they're walking around doing their shopping, minding their business, and they fall on something,
right?
Whether that be, like I said, a banana peel, water, some other product on the floor. And then social guests, we talked about, you go into someone's house and there's something there that you had no clue would ever be there,
Yeah.
but the homeowner knew. So that's kind of our basic thing. So that kind of gives everybody an example of what we're talking about.
Right. And then the other category, just think, invitee in a store is kind of dangerous condition.
Okay, yeah.
So the duty, the way that liability occurs in both situations is there's the foreign substance is also considered a dangerous condition. So for both, there's a dangerous condition that the store, which its employees, the knowledge is imputed to the store. So that the store, by and through its employees, knew or should have known there was a dangerous condition, or the store, again, by and through its employees or agents, themselves create a dangerous condition. So a dangerous condition, foreign substance aside, think using a cheap product to wax a floor to clean it. A mat that as soon as you step on it, it just slides. Okay. Any number of things. There's, maybe there's a nail or some kind of a permanent fixture. It's not just like something on this shelf, fell and ended up being here. It's like, it's a situation where this was a condition that was there. It's not like it just happened. And the reason why that distinction is kind of important is because foreign substance cases really, it's as simple as this. Liability really comes down to just this. There has to be some evidence, and can the person injured show some evidence of how long that item was on the floor? Whereas in a dangerous condition case, generally, it comes down to, well, one caveat is, or can they show that a store employee put that foreign substance there, which is obviously difficult to prove. And dangerous condition, it's basically just, it comes down, it's not really a time issue. It's just, did they know about it or should they have known about it? When they ordered this mat, maybe they got it for a little cheaper. Did they test it out? Did they know this thing was just going to fly up and you were going to slam your head the second you walked over it? Is the tile itself that they used, was there issues with that? Was there a for lack of better terms, janky shelf holding lumber that it was just imminent to one of the pieces to slide over and just knock you on the head? So that's kind of the major distinction between the two. And in my experience, foreign substance cases it's much more of a challenge to establish liability.